Thank you all for attending today's CLE, How to Read an Insurance Policy and Actually Understand It. This is one in a series of many virtual programs that the Law Alumni Association and Gold Group are hosting as a service for our alumni and law students. If you're interested in attending other upcoming webinars and CLEs, you can register on the UB Law School website. You can also listen to past webinars at no charge on our new alumni education webpage. To receive discounts and select free 1-hour CLEs, please consider becoming either an annual or lifetime member of the UB Law Alumni Association. And finally, I would like to thank the Gold Group sponsors who have helped underwrite the costs associated with these events: Chicago Title, Council Press, Equitable Advisors, Jack W. Hunt and Associates, and Precision Resolution LLC, and Paramount Settlement Planning LLC. Now, just a couple brief administrative points. You will be muted during the course of the presentation. If you have a question, please use the chat room, and we will try to address the questions at the end. At some point during the CLE, the course code will be announced, and I will also place the code in the chat room. You will need this code for the attorney verification form, which is required to issue you your CLE credit. Please also return the program evaluation form found on that page. It is now my pleasure to introduce our speaker, John R. Ewell, who is an associate with Gerber Ciano Kelly Brady, LLP, and also a 2016 graduate of the law school. John concentrates his practice on insurance coverage litigation and analysis in New York and New Jersey, insurance regulatory matters, reinsurance, and civil defense litigation. He is a member of the firm's Insurance Solution Practice Group, where he focuses on pre-suit proactive resolution of matters. He handles all aspects of litigation in state and federal courts around the United States in such areas as product liability, professional liability, premises liability, and general negligence. John received his Juris Doctor cum laude from the University of Buffalo Law School, where he was a publications editor for the Buffalo Law Review. John is also an alumnus of Canisius College, where he received his Bachelor of Arts degree in English, graduating with all college honors. And with that, now I will turn the presentation over to John, and our program will now begin.
Thank you. All right, so today I want to discuss how to read an insurance policy and actually understand it. All right, and why is this important, right? Whenever I go to a CLE, I'm always kind of listening for the first couple minutes to figure out, is this something that I'm going to benefit from? Am I going to be better at practicing law after sitting through this presentation? So that's kind of where I want to start with, of why insurance matters. And for plaintiff's attorneys, do you know if you're leaving money on the table? I have an example. I settled a claim a couple weeks ago for about 10 cents on the dollar because the other side, my opponent, didn't really read the insurance policy. So they probably could have recovered another $100,000 had they done that or known what to look for. Defense attorneys, insurance coverage is important because of risk transfer. A lot of folks understand contractual indemnification, which is important. But if you dab a little bit into additional insured coverage, that's another effective way of risk transfer and getting another insurance company or someone else to pay for your client's defense will really make you look like a winner in your client's eyes. And then for business attorneys, in-house counsel, most businesses usually buy insurance. Do you know what you're getting? Do you know what the coverage is that you've bought? And if you get a disclaimer letter, do you know how to evaluate whether that's proper or not? So these are some of the reasons why, in my opinion, insurance is important. There's also competency and avoiding malpractice if you get too far into these issues. So after today, you'll understand the big picture of insurance coverage, the difference between first party and third party insurance, how to read any insurance policy and understand the grant of coverage, exclusions, and conditions. And the reason this is because every insurance policy I've read is always comprised of essentially these three components: the insuring grant, the exclusion, and the conditions. And if you can work through each of those sections of the policy, you can figure out the insurance coverage analysis yourself. And towards the end of the presentation, I'm going to give you a systematic approach for you to conduct your own insurance coverage analysis that you can use to analyze any claim. So this honestly isn't rocket science if you know the process and you know what to do. And to be honest, anybody can really do it. It's it's just a matter of knowing what steps there are. And then we're going to close out today's discussion by talking about New York Insurance Law 3420D, which is important for liability disclaimers for bodily injury and death cases. I do have the chat box up. I see that Mariah is eating in front of us. That's okay. Feel free to turn off your camera if you want. If you have questions, feel free to type them in the chat box. We'll also do a short Q&A at the end. And can everybody hear me okay? If not, let me know if the volume isn't good enough, just in the chat. So what do you need to understand insurance coverage? And insurance coverage really isn't hard once you get past the mindset. A lot of folks look at insurance and say, oh, this is going to be really, really boring. It's going to be really dull. Once you get past that mindset, you only really need three things: reading comprehension, basic legal research skills, and a mild amount of perseverance, not even a lot. I find a strong cup of coffee helps. It's essentially contract review, so a little caffeine doesn't hurt. But there's really no reason that any attorney can't sit and do the coverage analysis, figure out whether there is or is not coverage. And most importantly is reading the policy, even if it gives you a headache. If a client called you and had questions, said, oh, I entered into this contract. Do you think I have to do this under the contract? Would you give your client advice without looking at the contract? Probably not, right? You would probably tell them, oh, I need to see what the contract is, see what you agreed to in order to tell them what their rights and obligations are under the policy. In any discussion of insurance, I want to start at the beginning with there's a distinction between first party and third party insurance. So these are the two types. And the difference is really who's buying the insurance and what kind of claims it's protecting against. So first party insurance applies to the insured's own property. An example of this would be homeowners insurance. So I have a home here in Buffalo and I've bought homeowners insurance covering the building. So if my home burns down, I can submit a claim to my own insurance company and they will pay for the damage. The other type of insurance is called third-party insurance, which is often referred to as litigation insurance. And that provides defense and indemnity against claims and lawsuits brought by third parties. So that's, premises liability claims, slip and fall, any kind of claim where it's a third party that's suing the insured. It's the third party who's really looking to collect the insurance money. And so here's an example of first party. Like I said, here's my house that's on fire, but because I bought homeowners insurance, I can submit a claim to my own insurance company and be indemnified for the loss. And then these are different types of insurance policies that are first party coverage. So as I mentioned with the homeowners insurance, the property coverage part will cover your building, your structures like garages, personal property you have in the home. Commercial property policies are kind of similar. That's what a business would buy. It's going to protect the building if there's water damage, if there's fire, if there's vandalism damage. And then the other three that are listed there are forms of first party auto insurance coverage. Third party insurance is like I mentioned with the slip and fall. So if I left these marbles out here and this gentleman fell on them, he's going to sue me and I'm going to go submit that claim to my liability carrier. And so third party at its core covers liability claims brought against the insured. Most commonly is going to be under the homeowner's policy. There's a liability coverage part. So in addition to covering your home if it burns down, you also have liability coverage. So if you are not at work, not in a car, and you negligently injure someone, you can submit that claim to your homeowner's insurance company and they should owe you defense and indemnity. So let's say I'm downtown, I'm walking down the sidewalk and I end up tripping, another person. I didn't do it intentionally. I wasn't trying to knock this person down, but they fell due to my negligence. I can submit that claim to my homeowner's insurance company and the insurance company will pay for me to have a defense attorney defend against that claim. So your homeowner's policy actually is with you wherever you go. It's usually anywhere in the United States and Canada. So uh, keep that in mind that if you do, or if you have a client that ends up negligently injuring someone, they may want to submit it under their homeowner's insurance coverage. By far and by and large, the most popular form of coverage that I deal with is commercial general liability, because businesses need insurance coverage for claims brought by third parties, not claims brought by employees that would be covered by workers' compensation. But if you have guests, visitors, pedestrians, folks visiting your business, or if you're working at construction sites and dropping construction materials on them, you're going to need insurance coverage for that. So most of our discussion today will be in the context of commercial general liability coverage and homeowners insurance with the liability coverage part. So we're talking about liability claims. And on this slide, we have other examples of third-party insurance. So insurance coverage may seem difficult, it may seem complicated at the outset, but it's really not. If you're able to read a flow chart, you're able to do coverage analysis yourself. So this is a chart, and feel free to download this, save this, print it, and stick it up next to your desk. But this is essentially what insurance coverage is at its core, working through essentially a flow chart, making decisions. Starting with the insuring grant, is the claim within the insuring grant? That is going to be a yes or a no question. And if the claim is not, then there's no coverage. Let's say you have a claim where it is within the insuring grant, you're going to move to the second step, which is whether there's any exclusions that are going to apply. If the exclusions apply, then there's going to be no coverage. The third step is conditions. Insurance policies have conditions, which are usually notice, cooperation. Doesn't matter what type of insurance policy you have. This is essentially the way that they are written. So assuming we have a claim that's within the insuring grant, yes. Do any exclusions apply? No. The third question is, did the insured comply with conditions? If the answer to that question is yes, then you've completed your coverage analysis and found that there's actually coverage for this loss. So we're going to go through each of these things individually, but you can use this when analyzing a first-party claim. You can use it when analyzing a third-party claim, or even a different type of insurance, because the insurance policies are all written with essentially these three provisions. So the insuring grant. The insuring grant is important because you have to start out recognizing that insurance is a contract. And like any contract, you have to look and see, what did the contracting party agree to do? And that begins with the insuring grant. So if you have a commercial general liability policy, or if you have a homeowner's policy that has liability coverage, there's going to be an insuring grant that's going to say that we will, and I'm condensing this down from the paragraph that it would be in the insurance policy, but it's going to say that we will defend of claims of bodily injury or property damage resulting from an occurrence. And so those three terms are really important: bodily injury, property damage, occurrence. Because if you don't have bodily injury or property damage, it's not within the insuring grant. If you have an allegation or a claim that is not resulting from an occurrence means accident, then it's going to be outside the coverage grant. So essentially, this removes coverage for intentional conduct. If I pull a chair out from beneath someone and my aim is to make them fall on the floor, I intended for them to get hurt. That's not going to be an occurrence. That's not going to be an accident. And the duty to defend extends even if the claims are fraudulent, false, baseless. So the insurance company can't decline to defend an insured just because there's evidence that the claim is fraudulent. It's really spite litigation, or a falling out between the parties. There's still going to be a duty to defend as long as there's an allegation of bodily injury or property damage resulting from an occurrence. And the second part of insurance is the carrier also agreed to indemnify covered claims, which what that means is at the end of the case, after we've had a trial or after we've investigated the facts, they're going to pay the judgment or the settlement if there's no exclusions that apply and as long as the insured complied with the terms of the policy. So a lot of folks, when looking at insurance policies, want to think in terms of tort terms. Ideas like, having a duty, breach of that duty, proximate cause, and those are all tort terms. So it's important when you're reviewing an insurance policy to step back from the world of tort and realize that tort law doesn't necessarily apply. It's really contract language. It's really contract analysis. And therefore, it's really a breach of the contract or compliance with the contract. It's going to be in those terms, breach of the contract. And in insurance contracts, there's really two duties that are extended. And this is what I was discussing before. There's a duty to defend, and then there's a duty to indemnify. And these are two distinct, different things. And it's important to understand each of them and how together they make up the insurance policy. So the duty to defend is what I mentioned a moment ago, that the insurance company is going to provide a defense lawyer to defend you against, allegations that you've injured someone. And what matters is what's alleged. So you take the complaint and then you take the insurance policy and you set them side by side. And you read the complaint, you read the insurance policy, and then say, okay, based on what is being alleged here, does this fall within the policy's coverage? It doesn't matter whether the allegations are true or false. It can be completely fraudulent. It can be completely false. But what matters is what is being asserted and whether that would trigger coverage under the policy. That's different than the duty to indemnify. The duty to indemnify is the duty to pay settlements and judgments, and that depends on facts. The duty to indemnify isn't triggered until the insured's liability has been established. So usually that would be going to trial. A verdict is entered against the insured defendant. That's what's going to trigger the duty to indemnify. And at that point, the facts matter. It doesn't matter what was alleged at that point. It doesn't matter what was said. What matters is the facts as they are, and the insured's liability has been established. And so that informs carriers when they're making decisions leading to mediations, settlement conferences. They're going to be looking at this from the lens of, if this case goes to trial, is the insured defendant going to get hit with liability? Because if so, they're going to work backwards from there, and that's what's going to push them to contribute money in order to settle the case. So one of the things that I see quite often is, complaints will allege other causes of action. Sometimes they have nothing to do with property damage, bodily injury resulting from an occurrence. And so I want to give you some examples, because there is really no everything insurance policy. There's really no policy that's going to cover literally everything. Insurance policies cover what they say they're going to cover. And so damages sought for something other than property damage or bodily injury are not going to be covered. So claims of lost revenue, lost goodwill, that is something that would be outside the grant of coverage. So let's say I make components and I sell you these components, you're going to put them in your product, and then you distribute this product and sell them. Well, the problem is that that component I gave you is defective. So when people buy your product, it fails. Nobody wants to buy your product anymore. And then you sue me saying, John, this is really your fault. I lost all this money because now I've got all these defective products. Everybody's suing me. And I've lost, a lot of goodwill here. My name is now tarnished because of your defective components. That's a claim that's not going to be covered by liability insurance generally, because it's not property damage or bodily injury. Same thing is true with breach of contract. So you assert a claim against me saying that, John, you didn't finish this work, in accordance with the specifications of the contract. There was architectural plans. You were supposed to do it the right way and you didn't. That's a claim that's not going to be covered. CGL coverage is usually where the context where this one arises. And it's not going to be covered unless there's an insured contract. And just hang on to that for a minute. I am going to talk about what an insured contract is in a moment. But claims that, you failed to pay for labor, services, maybe at a construction site, that's going to be something that's also outside the grant of coverage. Intentional harm, such as assault, battery, sex abuse, fraud, those are intentional acts and therefore not an occurrence. So that too is going to be outside the grant of coverage. You're essentially seeking coverage for intentional harm. What's also not going to be covered is affirmative litigation. So sometimes you'll see situations where the insured goes out and starts, a lawsuit. They want to go prosecute their claims. Well, insurance isn't going to cover that. That's essentially offensive litigation. What you're going to get here is essentially defensive litigation. They're going to provide you a defense if you get sued. And if the carrier initiates coverage litigation, such as a declaratory judgment action, that is also outside the grant of coverage. So because your insurance company sues you or your client saying that, oh, we want to determine our rights under the policy, you can't submit that to your insurance company and ask them to provide you with defense. That's a breach of contract claim. So I've mentioned occurrence a few times, and for liability coverage to be triggered, there first must be an occurrence. An occurrence is defined in the insurance policy usually to mean an accident. So it's distinguishing between intentional conduct, intentional harm, from an accident. So with the picture here, we've got someone slipping on the banana peel that I left out. That's going to be an occurrence. That's going to be an accident. But going back to my example of me pulling the chair out from underneath someone, that's not going to be an occurrence because I intended for someone to fall and hit the ground. And that's important, especially when you get into claims of harassment, sex abuse. These CVA claims are, you have to look at the occurrence requirement because from the perspective of, let me just give you an example of a school. School hires a teacher. The teacher has inappropriate conduct with a student. From the teacher's perspective, that was not an occurrence, right? It was intentional conduct. But if you take a step back, and usually the school district would also get sued, you have to look at whether it was an occurrence from the perspective of the school. Did the school see this as something that was unexpected, unusual, unforeseen? And those are the questions you ask to figure out if there was an occurrence. So just because the teacher did something improper and intended to do so, doesn't mean that the school also intended that. This may have been a surprise to them and thus an occurrence, which they would get coverage for. With the insuring grant, there's one of the big pieces of insurance coverage litigation is who has the burden of proof, because the burden of proof, it changes depending on what part of the policy you're dealing with. If you're dealing with the insuring grant, the insured has the burden of proving that the claim is going to fall within coverage. So if you submit a claim to an insurance company, you say, I'm insured under this policy, it's the insured who has the burden of showing that. The insurance company doesn't have to produce any evidence showing that you don't qualify. They don't have that burden. And that becomes important in litigation because you have to start there with, can you prove that you are entitled to coverage? Now, for those who haven't downloaded the course materials yet, I've posted the PowerPoint. I've also posted the PowerPoint with my notes. Now, my notes have case law citations to New York law, so it may be worth downloading those, and then you can look up those cases if you run into the situation where you're analyzing and trying to figure out, where the case law is on this. It's right in the notes, so just so you know. All right, exclusions. An exclusion is a provision that refers to hazard, perils, circumstances, or property that is not covered by the policy, and that makes sense. The picture I have here is like a puzzle piece. So if you can imagine the policy as being a puzzle, an exclusion is essentially you start removing puzzle pieces. And for those areas, there is not going to be coverage. Because of carriers excluding coverage, they have to do so using very clear, specific language. And as the drafter of the policy, any ambiguity is strictly construed against the insurance company. So for exclusions, it's the insurer that has the burden of proof to show that the claim or the lawsuit falls within the exclusion. And what's important about this is sometimes policies are ambiguous, as much as I hate to admit it. But if there are two reasonable interpretations, one which favors coverage and one that does not, then an exclusion is ambiguous and a court is going to construe the policy against the drafter. And even though the insurance company who's trying to take away coverage, trying to remove coverage for those types of claims, they're going to have to, because they need to use clear, specific language if they want to make sure something's outside the policy. So I want to talk about some common exclusions in liability insurance. And this is again going to be within the context of CGL coverage. So this is claims brought against business who bought insurance. CGL coverage is mostly standard forms. So probably 90% of the time or more, most companies have it written on standard industry forms. So these are essentially common exclusions that you would see if you were looking at a company's CGL policy. There are some people that buy manuscript forms, which just means the insurance company wrote the entire thing themselves, and that's much rarer, but those exclusions can differ. But most of these are standard form exclusions in a CGL policy. So the intentional acts exclusion, this is essentially the opposite side of the coin for an occurrence. I mentioned before how for liability coverage to be triggered, there has to be an accident. The intentional acts exclusion is essentially the other side of the coin. This usually says something to the effect that, if you intended the harm, then there's not going to be coverage, right? So my example here is, this was a news story a couple of years ago. A woman was driving over her cheating husband with her Mercedes several times. So she's, driving over him, reversing, going forwards and backwards. I know it's not a claim against a business, but I thought it was a good illustration of intentional acts versus accidental conduct. CGL policies also have a contractual liability exclusion. And this quite simply excludes coverage for damages due to breach of contract, because quite often businesses are going to have a contractual relationship, and it's from that contractual relationship that someone else is either going to get hurt, or the contracting party isn't going to perform the terms of the contract, resulting in litigation. So claims like breach of warranty, failure to comply with contract terms, those type of claims are going to fall within this exclusion and not be covered by the policy. However, there is an exception that restores coverage, and that's certain contracts that are called insured contracts. You might think of these as contracts that the insurance company is comfortable insuring. So contracts such as leases where the tenant agrees to indemnify the landlord if someone visiting the property gets injured, that would be covered under the exception. Also, trade contracts for indemnification. So you might think of this in the context of construction projects where a general contractor retains a subcontractor, and the subcontractor says, yeah, I'm going to indemnify you if anybody gets hurt this project. That is something that is going to be covered under the exception. So it's important to read the exclusion and then also read the exception and see if your contract fits in. The workers' compensation exclusion and employer's liability exclusion, these make sense because essentially CGL coverage is not workers' compensation insurance. So if an employee of the business gets injured, that claim should be submitted to workers' comp. It really shouldn't be submitted to the CGL carrier. If they do, they're going to disclaim based on these exclusions. The employer's liability exclusion doesn't usually apply to additional insureds. So what I mean by that is it's narrowly drafted that it's the employee of the named insured who can't assert a claim. But if you have a construction project, property owner retains a general contractor, the general contractor agrees to buy insurance coverage for the owner, and then an employee of the general contractor gets hurt, they're still going to get coverage because this exclusion isn't going to apply. And now the aircraft, auto, and watercraft exclusion is a little bit unique. It excludes exactly what it says it does. It essentially says, we're not going to pay for aircraft claims, auto claims, watercraft claims. The most important one of those is auto losses. The point being that if someone's injured in a vehicle, that claim should go to the auto liability carrier. It shouldn't be submitted to the CGL carrier. The tricky thing about this is if you're in a state like New York and you have to raise this exclusion within 30 days or so, and I'm going to get into the timing further on, you can end up finding coverage for a car accident just because of an untimely disclaimer. So this is one of those that I think a lot of people aren't really aware of. And if the insurance company screws up, turns into millions of dollars, potentially up to $1 million or more for a car accident that really shouldn't have been covered in the first place. So this is one of the reasons why, tendering to all the potential insurance companies is important. Making sure that they disclaim timely is important. And, by doing this, you're going to do a service to your clients, because if you can stick this to someone else, it's found money. There's damage to property exclusions in a CGL policy, and they're usually found at exclusion J. They're a little bit unique. J1 excludes coverage for the insured's property. And the point there being, this isn't first party insurance. So if the building burns down, the business doesn't submit the claim under this policy, a commercial general liability policy, that should really be submitted to the property insurance company. Can be the same carrier, maybe it's not, but these are different types of coverage is the point of that one. And then J5 and J6, this comes up really in like the construction defect context, as well as the context where you have mainly the construction defect context. So if you have contractors, or the insured is a contractor and they're performing work and they damage someone's property, that really isn't covered. That wouldn't be covered under the policy, because CGL coverage isn't like a surety bond. We're not guaranteeing that the contractor is going to do this job in normal workmanlike fashion. So that's why these exclusions are here, saying essentially, we never agreed to guarantee somebody's work. And going along with that is the damage to your work, your product exclusions. These essentially say that, if property damage results due to, the insured's work or their contractor, or because of a product the insured made, the insurance company isn't going to cover that. But what is important here is that consequential damages would be covered. So let me give you an example of that. Let's say I hire someone to come over and install windows in my house. And for whatever reason, window contractors tend to be bad at their jobs, because I see a ton of these claims. And they install the windows in my house, but they're supposed to install this flashing to make the water run back out towards the outdoors. And instead they put it on reversed, and instead it causes the water to flow into my house. So claim gets submitted under their insurance policy. The insurance company is not going to pay for the contractor to come back, remove the windows, and install new ones. What would be covered are consequential damages. So based on this example, let's say water is now running in through the exterior of the windows because they're not put in correctly. And now it's damaging my drywall, it's ruining my floors. This water's pouring in, and now I've got to hire someone to come in and replace the drywall. That's a consequential damage. So that would be covered. Same thing with like having a roof contractor. Roof contractor does a bad job. The insurance company isn't going to pay for the contractor to come back and do the work correctly. But if they put a bunch of holes in your roof and now water's pouring in through your house and is ruining your ceilings, it's ruining your walls, it's ruining the trim, the finishes, that's a consequential damage that would be covered by liability insurance. And the reason for that is accidental property damage, which that's the whole goal of liability coverage, is covering accidental property damage and bodily injury. There's also a product recall exclusion, which just means if the insured sends out a defective product and then they essentially have cost associated with recalling it, it's not going to be covered by liability insurance. You can buy, if you're a manufacturer, you can buy product recall coverage, but it's not going to be covered by a CGL policy. Independent contractor exclusions are very important, because especially where if you're handling claims where your client hires someone to perform renovation or construction work on the property, and then all of a sudden one of the workers gets injured. A lot of the subcontractors, even some of the general contractors, will have an independent contractor exclusion, which is a big problem because it excludes coverage for essentially construction worker injuries. And a lot of folks don't realize that until there's litigation, and at that point, it's too late. So this is really a hot area of insurance coverage, because you have to essentially pay a lot of money to get coverage for these kind of cases. And when you retain a contractor to do work, you don't really know. You haven't looked at the insurance policy, so you don't know if there's going to be coverage for, uh, workers who get injured at the job site or not. And then toxic torts are essentially excluded. So lead claims, asbestos claims, pollution claims are usually excluded as well.
John, if I could just jump in and announce the course code.
Sure.
This is a good time. So the course code for this CLE is coverage. Again, that's the word coverage. And then somebody had also requested to announce the link for the materials and forms. So the URL, I'll just read it off. It's www.buffalo.edu/CLE/201203.html. And I'll also put the course code in the chat room. Okay, thanks.
All right, and Mariah, I just saw your question. Can I explain that again?
It was where you were talking about the exceptions, the exclusions and exceptions, and you talked about the airplanes, autos, watercrafts.
Yes.
And you said something like, this is important, this is confusing, this is something, and you just kind of zipped right through it.
Sure. Well, let me go back for a moment. So
I think you were speaking faster than my ears were able to listen. I lived in Virginia for 30 years, so.
All right, sorry, I talk as fast as
Okay.
a New Yorker, so I apologize. All right, so backing up, CGL coverage, which is what a business is going to buy, it excludes coverage for contractual liability. So claims that the business didn't, failed to comply with the terms of the contract. They didn't do their work in accordance with the contract. Those type of claims are not going to be covered. Claims that you breached a contract to pay a debt, you owed us this money, you breached the contract. Those type of claims are not going to be covered because there's a contractual liability exclusion.
Correct. Okay. Yes.
Does that make sense?
Yes.
Now,
totally. Yes.
what makes it a little more tricky is there are certain contracts that insurance companies are comfortable insuring. So in limited circumstances, there will be coverage for breaching a contract. Usually that's in the context of a construction site project. So I'm building a building. Let's see. I'm building a building. I hire Mariah to go out and she's going to be the general contractor. She's going to go build this thing. And then someone gets injured on the job site. Now, Mariah's insurance policy is going to have a contractual liability exclusion, but it is going to have an insured contract exception usually. And what that is usually going to say is, if part of your trade contract is to indemnify someone else, that type of claim would be covered. I could do this in a different example, would be a snowplow contractor, right? So let's say you've got a grocery store. Grocery store hires a contractor. They're going to come out, they're going to plow, they're going to put down salt. And the contractor agrees in a contract that if anybody gets hurt because of my snowplow operations, because of me coming to plow the snow and salt, or maybe fail to salt the driveway, then the snowplow contractor is going to be responsible, and that they will defend, indemnify, and hold harmless the grocery store. So those are the type of contracts that are going to be insurable contracts or insured contracts.
Yes.
They're claims that really, the whole point being, if there's a bodily injury, that's something that's going to be covered. And, obviously insurance companies recognize that with businesses, they're going to enter into contracts as part of their business, and they're going to agree to indemnify other people. And they're fine with that as long as that is your business. So that would fall within an insured contract exception.
There always has to be someone ultimately to look to for the liability. Yes. Okay. Got it. Thank you.
Yes. All right. And I apologize for the pace. I've got a lot to cover.
No, that's all right. Keep moving.
All right.
Keep it moving.
All right. I'm going to skip on to conditions. So conditions really comes down to notice and cooperation. Notice is, and it makes sense if you think about it. insurance policies require the insured to notify the insurance company if there's an accident. So there was a slip and fall, that you're supposed to call the insurance company, let them know that the slip and fall happened, that somebody got injured. 6 months later, when the lawsuit comes in, tell the insurance company that the suit has come in, you've been sued in court, and immediately forward the suit papers to the insurance company. So these are going to be found in the conditions section of the policy, but realistically, it makes sense. The insurance company can't investigate the claim, they can't defend against the claim if they don't know about it. So if there's an accident, someone gets injured, you see the person taken away in an accident, in an ambulance, there was an accident, someone got hurt. At that point, it's important to put your insurance company on notice. Which brings us to late notice. So in New York, the insurance company cannot just simply disclaim because the loss was not timely. New York imposes a prejudice requirement, which means that if the insurance company receives notice within the first 2 years, the insurance company has to prove that they've been prejudiced in their investigation and defense of the claim in order to avoid coverage. At a certain point, that burden shifts over to the insured. If they've waited 2 years since the accident to put the insurance company on notice, they now have the burden of showing that there was no prejudice, saying that, well, the situation really isn't any different than it was 2 years ago. The witnesses are still around. You can still get all this information. And in New York, it's a unique rule. The claimant has the right to give notice. So if you are an injured person, you or your attorney can notify the insurance company of the defendant if you can find that out, and that will be deemed timely. There's also a duty to cooperate, and that sounds like exactly what it is. It's cooperating with the insurance company by providing them with documents, information, appearing for deposition and trial. It's cooperating with them with respect to risk transfer, which would be contractual indemnification. If you entered into a contract with someone else, usually in a business context, you can't just say, well, Joe's my buddy, so I don't want to sue him, even though he agreed to indemnify me. You have to cooperate. And the insurance company has the burden of proof. The insurance company has to show that it acted diligently, trying to bring about the insured's cooperation, that its efforts were essentially reasonable, and that after trying to get the insured's cooperation, they had willful and avowed obstruction, which is a pretty heavy burden. It's pretty high. It's hard to disclaim on non-cooperation in New York. You pretty much have to have someone telling you off directly. They're not going to cooperate. They're not going to show up for examinations under oath in order to establish non-cooperation. Which brings us back to the coverage chart. And so now looking at the chart, asking, is this claim within the insuring grant? Now you can think about that, was there bodily injury or property damage resulting from the occurrence? Do any exclusions apply? Was there compliance with the conditions? So this chart should make more sense now that we've discussed each of those topics. I do have about, let's see. All right, we're going quickly because I still got about 10 more slides to go. There's also in most CGL policies, it's often in homeowners policies as well, is a certain kind of coverage. It's called personal and advertising injury. And this is really something that the insurance industry has created. It's different than, the bodily injury and property damage resulting from the occurrence coverage. That's usually referred to as coverage A. What this provides coverage for is intentional torts, which are essentially labeled as personal injury offenses. And it also covers advertising injury. So if you look at the definition, this is how most CGL policies will define this. And very few people, I think, actually know this coverage exists. You don't see necessarily a lot of claims on this, but it covers intentional acts such as false arrest, false imprisonment, claims of malicious prosecution, wrongful eviction, or invasion of privacy by a landlord. These are claims where it's not going to be an occurrence and there is no occurrence requirement because this is all intentional conduct. Like slander is an intentional tort. It's not an accidental tort. And then I've actually purposely put the line break here because the three at the bottom are the advertising injuries. So this is especially in the CGL context where businesses from time to time will, whether intentionally or not, use another business's advertising idea or disparage another company's product or their services. And, if the other folks get upset enough to complain, then they can get coverage for this if the lawsuit is filed, as well as copyright infringement, trade dress infringement. So if you have a car dealer, your logo is too similar to the one that's on the other side of town, there's litigation, business can actually get coverage for that type of claim. And malicious prosecution, I did see someone sent me a question. Malicious prosecution is if, I end up calling like the authorities and I say, they've got to prosecute this claim against you. You did this wrong. It's a tort claim. And as a result, the town ends up having hearings. They end up, essentially trying to prosecute you based on my word that you're doing something wrong. And at the end of the day, you were exonerated. Then that's a claim for malicious prosecution. So it's usually in the tort context. And these are essentially all torts that are listed here. Suit limitation. I want to bring this to your attention because, as most of you probably know, the statute of limitations for breach of contract is 6 years in New York. Well, with insurance policies, it can be reduced to as little as 1 year, and that will be upheld. So it's always important, if you are going to sue an insurance company, you've got to know what the timing requirements are, because if your client bought an insurance policy with a 1-year statute of limitations and you're beyond that, you're going to be dead in the water. And I think most people don't know about that, but it puts the insurance company position that I like, where you can just move to dismiss based on statute of limitations and win. All right, I know we're going fast. Just a lot of information I want to cover. So with liability claims in New York, there's unique rules. New York's one of the only jurisdictions that does this. New York law says that if you want to disclaim coverage for bodily injury or death, so it's only bodily injury or death claims that occur in New York, you have to do so within a reasonable amount of time. And this is, the term reasonable comes from a statute. It's called Insurance Law 3420. You may have heard about it. And courts have interpreted the statute to mean that it's within about 30 days of notice. So if you're going to raise an exclusion or a breach of a condition, that has to be raised in bodily injury or death cases within 30 days. If not, then the disclaimer can be struck down as being invalid, meaning that there would be coverage. Now, the 30 days isn't necessarily a strict rule. If the insurance company is doing documented, reasonable claims investigation, that time of 30 days can be extended. Let's say the insurer or the claimant aren't responding, you're trying to get more information, trying to understand what's going on, you're not getting information, the insurance company isn't just sitting there doing nothing. So, equity principles basically will extend that past 30 days. And if you're waiting for information like police report, essentially you're missing documents that you need to evaluate the claim. And insurance companies can also request an examination under oath, which you could think of as essentially the insurance company's deposition. You can call the insured in, it's pursuant to contract, so the CPLR doesn't apply. The other side can't ask questions, they can't make objections, and the insurance company gets to essentially ask questions as part of their investigation, learn more about the loss, and it's going to be an admissible form they can use later on at trial. All right, so continuing with 3420, if there's bodily injury or death that occurred in New York, the insurance company has to copy the injured person, so that would be the plaintiff, and any other claimant. So you might think of that as co-defendants, people that would assert claims of contribution and common law indemnity. So when an insurance company disclaims, these folks should be copied on the letter. They don't have to have a separate letter issued to them, but at the CC at the bottom, these folks should be listed. And if they're not, that makes the disclaimer invalid as to that party. So this is a stringent rule. It gets insurance companies into trouble from time to time. So it's very important to be aware of this, and especially for the insurance companies to comply with it. But with a non-New York accident, this rule is not going to apply. The statute by its terms only applies to bodily injury or death inside New York State. So if some folks from New York drive over to New Jersey, they get into an accident, New York's 3420 is not going to apply. So what that's going to mean practically is the insurance company would have more like 3 to 4 months, or even a little bit beyond that, to investigate, finalize their coverage position, and it's not going to be deemed waiver or estoppel. And property damage claims, there's even more time, because property damage claims aren't subject to 3420. So if the insurance company is done literally nothing for 3 to 4 months, that's actually okay. And, I've seen cases where, nothing has happened for a year and it's still not going to be a problem because essentially there was no prejudice. And the whole point of it is the stricter time frame applies to death and bodily injury that occurred in New York. So that's the main takeaway to remember with 3420. Legal research, if you're evaluating a coverage letter, it's important to look at, the exclusions that were raised. Has the exclusion been found to be against public policy and therefore unenforceable? Or has the exclusion been found to be ambiguous? And you do this just by literally copying the exclusion right into, Westlaw, Lexis, and see what cases come out, and then see how the courts have interpreted it. So this is why insurance coverage may seem tricky because it has its own subset of cases. But if you just copy and paste the exclusion into Westlaw, Lexis, you can find, is it enforceable? Is it ambiguous or not? And how the courts have treated it. So putting it all together, and this is what I'm going to close on. I see we're running out of time, but we're right at the end anyway. So I want to give you a systematic approach for doing insurance coverage analysis. And this is the approach I take, whether it's a $500 claim or a $5 million claim. This is always the same approach. Doesn't matter if it's first party insurance, third party insurance. This is kind of framed up for more liability coverage, but you start out by reading the claim notice or the suit. Read the lawsuit, what is being alleged, what is being claimed. That's the first thing I do. Second thing is then now you look at the insurance policy. This is what I talked about with comparing, essentially setting the complaint and the insurance policy side by side. And start with the insurance grant. Is bodily injury alleged here, or is it property damage alleged? Because if neither of those are alleged, that's not going to fall within the policy coverage, or a personal advertising injury alleged. Is there an occurrence? And was it within the policy period? Those are questions that can basically be answered just by checking a box as you're reviewing these. And then the next step is exclusions. Do any exclusions apply? And if so, does the exclusion bar all of the claims or only some of the claims? Because sometimes you'll have situations where some of the claims are covered and some of them are not. You might think of that as a situation where it's mixed claims, which is a good term for it. Some of the claims are covered, some of the claims are not. And if some of the claims are not, then you can know that there's room to argue for some coverage, even if not all the claims covered. And it's also important to read the conditions. Was there timely notice? Was there cooperation? Those are usually very simple to answer. Was the letter timely? If you're in New York and it's a bodily injury or death case, was the disclaimer issued within a reasonable amount of time? Insurance company have a really good exclusion, it can definitely apply, but if they sat on it for 3 to 4 months and didn't get the letter out, then the exclusion could be waived. And was the claimant copied? Was the other co-defendants copied? Because if you're that claimant that wasn't copied on the letter and you're finding out about this 2 years, 3 years later, then that disclaimer is not going to be valid as to you, which is great because then there's going to be coverage. And then the last step was what I just mentioned, doing some legal research to make sure the exclusion is or is not enforceable. I know we went fast, but I wanted to cover a lot of information. Do we have questions?
Thank you, John. Thank you so much for your time and for your presentation. While the questions come in, I just wanted to be sure that everybody sends in the attorney verification form and the program evaluation to Pat Warrington, so that way your CLE credit can be issued. And you'll also be receiving more information about our future CLEs, and the ethics CLE is going to be scheduled sometime in February 2021. Just so everybody knows.
I want to thank you. You did a very nice job. This is Mariah.
Thank you. And I should have promised you at the beginning, we weren't going to actually look at any blocks of text from the insurance policies. I didn't want to put anyone to sleep. So
no, you did a great job. You did a great job. I'm a contract lawyer, and I you did I thought your lead-in was perfect.
Oh, good.
It's a contract. Yeah.
It's a contract. That's what's important to remember. So I hope the information is useful. Save a copy of this somewhere. And, if you run into an insurance case, flip through, the case law is there. So if, hopefully that it's helpful.
Is your, is your information in the materials, right? So we can
Yeah,
call
let me
you.
see here. And yeah, feel free to give me a call. Let's see. I flip to the next slide. Okay.
Nice.
I have friends call me all the time and be like, I got this insurance claim. Can I run it by you? And, you know,
Great.
always happy to help.
Thank you.
So any other questions? Usually somebody wants to talk through their insurance claim sitting on their desk that they don't know what to do with.
Okay. Well, if there,
Good job.
oh, okay. Okay. Thank you so much, John. That was great.
Okay. Thanks, everybody. Have a good day.
Bye. Thank you.
Bye-bye now.